All right, welcome guys to our webinar for today. I appreciate you attending. Looks like we got about 40 people on the line, so that's great. I think I can see my chat box this time, so you guys are welcome to send me chat messages. Just a couple quick housekeeping things. You guys are welcome to send me your questions. Please don't wait till the end. I get tired of hearing myself talk. I do let people know that if you have a super specific question that might not be applicable to the broader audience, I might ask you to follow up with me after the webinar in person, but please send questions. I don't know if some of you brought contracts today with some language that you have questions about, but you're welcome to send that to me in the chat or to email me, landon.blake@redefinedhorizons.com. We can take a quick look at it and talk about it if it's appropriate. I will also let you know, I tend to ruffle feathers on occasion. I don't think this is a super controversial topic today, but please take me with a grain of salt. Don't take me too serious. We'll probably make fun of lawyers and civil engineers and some other things on the webinar today, so don't get deeply offended. All right, and we have a sponsor for today's webinar, which is really cool. So we want to thank them. Hopefully you guys can see their website on your screen. It's Tate. They are an engineering company, and they are looking for good land surveyors that understand contracts. So if you are thinking about career change, please reach out to those folks and let them know that you heard about it on our webinar today. That would be really cool. So we haven't had a sponsor yet since I've been doing this webinar, so that was really cool. So thank you very much to the folks over there at Tate. We appreciate that. All right, so we're going to talk about contracts today. I wasn't even sure if we were going to get anybody to sign up for a webinar on contracts, but we did. We actually got quite a few folks, so that's good. It is not a fun topic, but it is a really important topic, and it's also not really a technical topic. It is more of a business topic. So I would imagine that a lot of the folks I have on the webinar today are project managers, or maybe in a business management role. Maybe we even have some company owners on board. So that's great. So we are going to talk about contracts. This is not something that I cooked up on my own. We actually got a request from a CLSA member, asked if we could do a webinar on contracts. So I told him I would try and put something together. It is really important. Contracts are really important. And I'll just tell you that I struggle to learn about contracts. I am much more comfortable now than I used to be. I was afraid of contracts for a very long time, and I think a lot of surveyors are. And I don't know why. It was just really hard for me to get anybody to teach me about contracts. So a lot of what I know about contracts has been self-taught. I got a little bit of help, but yeah, contracts were a really tough subject for me to learn about and get comfortable with. So hopefully I can share some of the things I've learned with you guys today if you were in a similar boat. I don't think you need to be afraid of contracts, and I think this webinar will give you some good tips that'll make you more comfortable with contracts. And so you as a survey project manager, you probably deal with contracts at some level, at least with you're probably preparing or reading a scope of services and maybe working to get a contract executed. But then when you become a business owner, you deal with contracts all the time. So I started my own company a year ago, and man, there are contracts for everything. So, your health insurance has a contract, your auto insurance has a contract, your office lease that you want to move into has a contract. You have subcontractor that have contracts. You have your clients have contracts. Like, there's stinking contracts for everything. So yeah, it's really important. It's important for project managers to know about contracts. It is really important for business owners or managers to know about contracts. So, and you don't have to be afraid of them. You don't have to be a lawyer. I'm going to give you some tips today, some really simple rules that I think you can follow that'll help you. Okay, so we're going to talk about, we're going to try and answer, I think I had 8 questions, sorry, 8, get my fingers the right way in the camera, 8 questions that we're going to try and answer about contracts today. So I'm going to try and keep this to 45 minutes. We'll rattle through that, and then we'll do we'll save 10 minutes at the end for questions. So one thing that we're not going to talk about today is I'm not going to take a super deep dive into scope of services, which are an important part of a contract. I think we should do a separate webinar and just talk about scopes of services. I can show you guys how we set set up our scopes here at Redefined Horizons, talk about what goes in them, what doesn't go in them, how you can set up a task library for scope. So we're not going to talk about that today. So scopes of services are a really important part of contracts. We're going to briefly touch on for just a couple minutes, but we're actually talking about the other stuff besides your scope, okay, that's in a contract. So all of the legal language that goes into a contract. So I will point out at the beginning of the webinar that CLSA does have a standard contract. It is a good contract. It is a fair contract. I encourage you to use that if you are not currently using a contract or you don't like the one you have. It's on the members only website. You can also email central office. Kim at central office can help you with that. So I actually use a plain language version of our organization's contract, CLSA contract. That is a contract I sign 95% of the time. So it's a good contract. I'm also an ACEC California member. If your firm is a member of ACEC, they also have a very good standard contract. It's a fair contract, which is what you want. It's not one-sided. So both of those are good, fair contracts that are not one-sided, and most clients will sign them. Okay, so just point that out here at the beginning. All right, so I got a quote for you guys that I'm not going to read you slides today, but I am going to read you this quote. So you'll see, we'll talk about this a few times today, but I'm a big, oh, you know what? I just realized you guys are seeing the wrong monitor probably. Let's try that. So I am a big proponent of plain language, and I try and use plain language in my business whenever I can. And so this is just a quote from an article about plain language contracts. So it says, a contract should not take countless hours to negotiate. Business leaders should not have to call an attorney to interpret an agreement that they are expected to administer. We should live in a world where contracts are written in an accessible language, where potential business partners can sit down over a short lunch without their lawyers and read, truly understand, feel comfortable signing a contract. A world where disputes caused by ambiguity disappear. This is a really important quote. If you don't remember anything else from today's webinar, I hope you remember this quote. This is contracts in a nutshell for land surveyors, right? And the basic rule of thumb is don't sign a contract you don't understand. You should not have to have your lawyer with you to read and understand a contract. I think it's ridiculous that we do that. You're not going to have your lawyer with you when you're executing the project, right? And trying to meet the terms of the contract. So you shouldn't have to have your lawyer with you when you understand the contract. Now, I'm not saying that's not ever important to talk to a lawyer about a contract. Sometimes it is important. The more critical or high dollar value of the contract, the more complicated the contract, the more important it is to get good legal advice. I always encourage people to get good legal advice. Having said that, you should not need a lawyer to understand the contracts that you are signing. Okay, so that's basically what the quote says, right? You need to be able to understand, business people should understand the contracts that they're going to sign. All right, so this is the first question that we're going to answer today. When does a land surveyor need a contract? And the answer is all the time. Basically always. Okay, so the law basically says if you're going to provide services as a land surveyor, you have to have a written contract. It's no handshake deals, right? There's a reason for that. Handshake deals cause problems. So the law says that you need to have a written contract. Now, there are a couple cases that I think that rule doesn't apply when it might be okay for a land surveyor to not have a contract. So let me tell you what those are real quick though. I forgot my clipboard with my meeting notes, so let me grab that. You can run out there, my clipboard out in the truck. All right, sorry about that, guys. My partner's running out to my truck to grab my clipboard. Okay, so what are a couple times when you might not need a contract? Okay, so if you already have a contract with a client and they want you to perform an additional task on a project, you don't need another written contract. And it actually says that in the law, okay? So you can perform additional services under an existing contract. And so what a lot of companies do, and my company includes my company, is if you do a lot of repeat work for one client, you might execute what they call a master services agreement, which is just a contract that covers all the work that you do for that client, and then they issue task orders. Now, I still think it's really important in those situations, even when you have a master services agreement, that you have written scope that goes with every task order. So that's important, but you can do that. You can do what they call master services agreements, which is just like a global contract. Okay. The other situation in which it might be okay to not have a contract is if you're doing pro bono work. So as an example, we're doing a survey right now for the local sportsman's club up here in Oakdale, California. And it's just volunteer work that we're going to do for the sportsman's club. You know, in a situation like that, you may not actually have to have an executed contract. I'm not saying that's not a good idea to have one, but that might be an area in which you don't necessarily need a written contract under the law. So there you go. Okay, but pretty much any other time, you need to have a contract. That's what the law says. And if you have a problem with a potential client and the board finds out you're doing work without a contract, you're going to look really stupid because it's in the law, it's pretty plain, and you just need to do it. So if you are not using written contracts right now, you need to start tomorrow. And it's not that hard. So that's when you need a contract. The answer is basically always. You always need a contract. Now, contracts don't have to be super complicated. You can have a half a page contract, right? My contract, I think, is 2 or 3 pages. It's not, you know, sometimes you get a contract from a big engineering company and it's 42 pages or something. You don't have to do that. You can have a super simple contract. And we're going to talk about some of the stuff that needs to go into a contract. But all right. So what needs to go into a contract? Okay, so we're going to talk about some of the things in more detail, but basically you need to do a few things. So you need to identify who are the parties to the contract, right? And it is important when you get a contract signed that you make sure the person signing the contract with you is the authorized person to sign contracts at that organization, right? So you don't want your contract signed by the CAD tech. It generally needs to be an officer of the corporation, okay, that you're dealing with, or an officer of the public agency. Okay, so, but you do need to clearly identify who the parties are, right? It's important if you have a corporate structure that you sign as an officer of the corporate structure, not as you personally. There's liability reasons for that, right? So I sign as Landon Blake, president of my particular corporate entity. Okay, so you want to identify the parties. Okay, you also want to identify what the project is. We usually just have a couple sentence description of the project. You want to identify that. Then you want to have your payment terms in there. That should be included in your contract. You want to have rules about how the contract gets terminated by either party, right? You want to explain in which situations the contract could be transferred to a different party. That's important. You also want to talk about limits on liability and duty to defend, which we are going to discuss. Okay, we're going to go over that in a little more detail because it's one of the most important things. Thank you, Danny, for doing that. And then you want to talk a little bit about how disputes, if they arise, are going to be resolved. Okay, most contracts have some language about that. And there's some other things we'll throw in there. We'll talk about today, like what you do about digital deliverables, and, you know, copyright, some of that kind of stuff. Okay, so that's what needs to be in a contract. That's basically the key stuff, right? I have studied some contract law. I'm not a lawyer, but I have studied some contract law. It's not a bad thing to do if you're going to be a business person. And, you know, the rules about contracts are pretty simple, right? And it says to be valid and legally enforceable, a contract has to have some of the things we just talked about, right? It's got to identify the parties. They got to be legally competent, right? It can't be a minor. They can't be crazy. You know, the contract has to be executed. You know, the consideration or the payment has to be clearly defined. And that's basically it. You know, that's basically some of the same rules that we use for a deed, right? A deed is just a contract to transfer real estate, right? So a lot of the rules that apply to whether or not a deed is valid also applies to whether or not a business contract is valid. Okay, so why do you need a contract? Besides the fact that the law tells you have to, there's some other really good reasons. So I would use written contracts even if the law didn't require it, right? So why do you need to do that? Okay, so I have a chart here on the screen. Hopefully you guys can see. And here's why most people in their mind think that they need a contract. On the left side, okay, in the purple boxes, okay, the very first thing they think about is I want to be able to destroy my opponents in court. Okay, that's why we need a contract. Because if there's a lawsuit, we want to be able to just obliterate the other side, right? And our contract needs to do that. Okay, then the second thing people think about is, well, if there is a dispute, we need to, you know, we want to make sure that we're going to court in California, not Delaware, and that needs to be in our contract. That's the second reason why we need a contract. And then the third thing, you know, surveyors think about is, okay, and the other reason we need a contract is we want to limit our liability. And that's you know, that's important, and it's important. Okay, the last thing people think about, if they think about it at all, is because a written contract establishes a mutual understanding between the client and the consultant. Okay, and a lot of times when you hear people talk about contracts, they don't even mention that, right? Okay, but we get this order of importance completely backwards, right? Okay, so I'm not saying none of these things are important, but we get the order of importance totally backwards, right? So the most important reason to have a written contract is to establish mutual understanding between the client and the consultant, right? What are you going to do? When are you going to do it? And how much is it going to cost? You want your client to know that, and you want it to be in writing, right? And I know me personally, like there are occasions when I get a client calls me, they've got a fire drill, we start work before I get a written contract in place, and then like, man, never fails. There's some kind of misunderstanding about what was included or not included for that price, and it causes problems, causes unnecessary conflict with clients, even with good clients, right? So that is why you want a written contract, ladies and gentlemen. It's not for those other reasons. It's because you want to establish a mutual understanding with your client. And we're going to talk about that later. Now, I think the second, now that has nothing to do with the law, right? And it's everything to do with good business practices. Okay. Now, the second reason I think a contract is important, the second most important reason is there are some practical ways to limit your liability in a contract, and you want to do that. Right now, you can't get rid of all your liability, and we're going to talk about that, but you can put some reasonable limits on your liability. Okay, and then the last two things, the two things that everybody thinks is the most important is the least important, right, in a contract, right? So if you're in a situation where you're trying to destroy a former client in court over a contract dispute, you've got way bigger problems than that particular contract dispute, right? So it's not the most important thing in a contract, and that's the first thing people think about, right? So if you sit down to draft a contract with that goal in mind, that you want a contract that's going to allow you to destroy your opponent in court, you're not going to do very many good business transactions, right? So I encourage you not to do that. So we get this backwards most of the time, right? And a lot of the reason why surveyors are afraid of contracts is because they think they have to understand how to destroy a legal opponent in court to negotiate a good contract. That's not true. All you need to have a good contract is the goal of a mutual understanding between you and your client. That is the most important thing. Okay. All right. So here's another quote for you guys. So in the private sector, plain language, which we're going to talk some more about, plain language has saved time and money for many organizations. And in this book on plain language, this author, Joseph Kimball, gives us some examples of that. So after the Cleveland Clinic simplified its billing statements in 2008, it saw a significant uptick in patient payments and was able to recover an additional $1 million a month. That's pretty amazing. So I will let you know, not only do we use a plain language contract here at Redefined Horizons, but we also have really simple, easy to read and easy to understand bills, right? And we put a lot of work into those bills. So we actually handcraft each invoice. We have a template, but it's something that we put together in some graphic design software. So we're not just dumping a report out of our billing system, because I don't think that's a good way to bill clients. And our invoices are beautiful and attractive and easy to understand. And we've had clients tell us that. And that's part of the reason we put that effort into it is because I think plain language and good communication is really important. And then this other company, Sabre Travel, introduced plainly written guidelines to help customers install its computerized flight information system, and they cut their calls to their help desk by 70%. So plain language is really important. Your contract should not read like something that Shakespeare wrote. That's what bad lawyers do, and it's not helpful. Okay. So if you get a contract like that, don't sign it, right? You shouldn't sign contracts that you can't understand that sound like they were written in 1650, right? Okay. So what kind of supporting docs need to go in your contract? Okay, so there are a couple of really important things I think that need to be in your contract. Okay, one of them is the scope of services. Okay, so generally your contract is, I don't want to call it boilerplate, but it's to some extent it is boilerplate. That language doesn't change typically from job to job. Your scope of services is custom tailored for every project usually, unless you're just doing the same thing over and over again. But at my company, we custom tailor each scope for each project. Okay, so generally what we have is a contract that doesn't change other than a few key pieces of information that we talked about, the identification of the parties and some of those things. And then the scope of services gets a lot of work, right, on every project. So the scope of services is what you, basically the document that you use to tell the client what you are going to do and what you're not going to do. And that's it, pretty simple. Okay, now there's some other things we put in our scope. We put our schedule in there. We have some information about compensation in there, but that's basically what it is. Okay, so I encourage people, put the other stuff in your contract, right? Limit your scope to schedule, payment, and what you are and aren't going to do, right? That keeps it simple. Okay, like I said today, we're not going to go into a deep dive into scopes, but you do need to have a good scope with every contract. Okay, and so I need to remember, we need to do another webinar on scopes. If you want to learn about scopes of services, if you're not being taught that at your current job, shoot me an email and remind me, Landon, we need a webinar on scope of services, and I'll work with Kim. We'll get that on the schedule. Okay, so the other thing that I really encourage people to do, and this is, I am a hypocrite in this area because I need to do better, but for most surveying projects, I think it's important to have a mapping limits exhibit, especially if you're doing topo. That should be included with your scope of services, right? That just avoids all kinds of potential misunderstandings about what is actually getting mapped and what is not getting mapped. On boundary surveys, we do a lot of boundary surveys here, and sometimes we can do that with just by simply identifying the subject parcels. You got to be careful with that, got to be careful using addresses or even APN numbers, but plug in your brain. You may not need a mapping limits exhibit on every boundary, but certainly when we are doing topo, my goal in this office is to have a mapping limit exhibit in the contract. And I can send you one of those. I'm happy to show you, give you an example. Pretty simple, 11 by 17 exhibit that we do. Okay, so the contract does need some supporting docs. I think those are the two most supporting docs. Now, there could be some other very important information. It could be something you get from the client. Maybe they sent you a set of construction drawings or an exhibit or a title report, some kind of survey request. So sometimes you want to reference those documents in your contract. So you can do that. You can reference them in your scope of services and attach them to the contract. Okay, so moving on. Don't forget to stop me if you guys have questions. Okay, so we want to talk about duty to defend. Duty to defend in the indemnification language is probably the most important clause in your contract. And it is also most frequently the one place where clients will try to slip really nasty language. And so the very first thing I look at when I get a contract from a client, if they want me to sign their contract, is the language that relates to duty to defend and indemnification. So let me take a few minutes and explain this because it is legal and it is technical and it is also very important. Okay, so most contracts will have some language related to duty to defend. Okay, what that basically means, it's also known as indemnification. What it basically means is if there is a lawsuit on a project, you agree to defend your client in court and pay all their legal costs, right, and damages for any mistakes that you've made. Okay, now, so that's the standard language. Now, here's the important part. The important part is, do you have to do that for your acts of negligence or not? Is it limited to your acts of negligence or not? So here's what, in my opinion, as a business owner, is acceptable duty to defend language. If I agree, I will agree to indemnify my client for their legal costs and damages for mistakes that I make due to my own negligence or my employee's negligence. That is okay. Now, the reason that is okay is because that is an insurable risk. That is what we call an insurable risk. If you have professional liability insurance, as a general rule, that type of risk is covered under your policy. We will talk a little bit more about insurance at the end of the webinar. Okay. Here's what is not okay. What is not okay is if you agree to defend your client and to pay damages for mistakes that are not a direct result of your own negligence. Okay. So let me give you a couple examples of what I'm talking about. You do not want to agree to defend your client for any problem that may result because you haven't met the highest professional standard or the highest technical standard, or even the technical standard in a certain specification, because more than likely, those are not insurable risks. And so you could be exposing yourself to risks that aren't covered under your professional liability insurance. So you cannot sign that kind of language. And well, you can sign it. It's a really bad idea. Okay. You may also find that some clients will put nasty duty to defend language that says something along the line of, you will defend your client if there's any kind of lawsuit for any reason. I've seen that in contracts. You really do not want to sign that language. There was a case in California that went to the Supreme Court a few years ago. CH2 and Hill got sued as part of I believe it was a condo project. and they had signed some bad duty to defend language, and they were held liable to pay defense costs for their client for a mistake that was not their fault. And that went all the way to the California Supreme Court, folks, and the court ruled against the consultant. So not a great legal precedent. Not something that we're happy with. Now, as a result of that court case, there were some changes in the law. Some legislation got passed. One of the things that ACEC was able to do was they were able to, it's basically illegal for public agencies in California to ask you to sign that kind of language. Okay, so cities, counties, and the state cannot ask you to sign bad duty to defend language like that. Now, they can still ask you to sign language that requires you to defend them for your own negligence, but the public agencies in California cannot ask you to sign contracts that require you to defend them for things other than your own negligence. Now, just because it's illegal doesn't mean agencies don't still ask you to do it. It's illegal to select surveying services on low bid, and about 50% of the public agencies in California still do that. So I'm not telling you won't be asked to do it. What I'm telling you is you don't have to do it. It's illegal. And if you're asked by a public agency to sign that kind of duty to defend language, you should reach out to me or to someone else in CLSA or to someone in ACEC, because we need to talk to that public agency and get that cleared up. They need to fix that in their contracts. But private parties can ask you to do that all day long. So you need to be on the lookout for that language. Okay, so it's really important. We'll talk a little bit more about it in insurance. Now, there's one other thing I want to mention about duty to defend. The other thing that's important about duty to defend is if you agree to defend your client for mistakes of your own negligence, one of the sticky issues is when does that determination get made? In other words, when is it determined that it's your fault or not? Because if that isn't determined until after the court case is over, you could be in a situation where you are fronting all the legal costs for your client until the court decision gets made. That's a pretty big deal, right? If you run a small business like me, cash flow is a challenge. Cash flow management is a challenge anyways. Hey, you don't want to be footing your client's legal bill for 2 years while you wait for a court decision, right? So you got to take a look at that language in the client. What you generally want is you want to agree to reimburse your client for their defense costs if a judge makes a decision that you were negligent, right? That's a smarter way to have the language worded. Okay, and the other reason that's really important is you want your client to have an incentive to settle that dispute. If you're paying all the legal costs up front, your client is going to have very little incentive to settle, and that is a bad thing, right? We want people to have an incentive to settle disputes outside of the legal system. Okay. Now, I probably just lost some people. I probably had some people just fell asleep. All right. I'm sorry. I know that was painful. Duty to defend is the most important thing in your contracts, in my opinion. You need to read that. That should be the first thing you go find. Okay, now, if you get a contract and you're reading the duty to defend language and you're like, I have no idea what this means, right? You can check with your professional liability insurance carrier. You can call me or email me. I'll take 5 minutes and look at some language with you, right? The key thing is, if you're not sure, don't sign that contract. Okay, now, let me take a quick pause here, because there are going to be some people that say, I don't have a choice. I have to sign the contract. There are sometimes business reasons why you may sign a contract with language you don't like. And I understand that. I have, as a business owner, once or twice, signed a contract with language I didn't love because I needed the work. Okay. I will tell you, I have never signed a contract with poison duty to defend language, and I never will. Okay. So just remember, if you sign a contract with poison duty to defend language, it could cost you your business. So you just have to decide if that risk is worth it. Okay. This is the most dangerous part of a contract. Is the duty to defend language. All right, enough depressing news about duty to defend. Let's move on. Okay, if you have questions about duty to defend, hit up the chat box. I think I can see the chat box. So, all right, let's talk about digital deliverables for a minute, because that tends to be a source of potential conflict with clients. So let me tell you how I handle digital deliverables. Different firms are different. So I'm comfortable providing digital deliverables to a client. We do it all the time. But I have a couple rules about digital deliverables, and I put this in my contract. One is the PDF. I always provide a PDF deliverable. The PDF deliverable controls. So I send a wet signed PDF deliverable. You use my CAD files at your risk, right? So I will give you CAD files, right? But the signed deliverable is what I'm going to be liable for. Okay, I do that for a couple of reasons. One is I don't want people running around with a CAD file when they haven't paid me for a signed deliverable. And the other reason is, so for example, I have a lot of engineers that like to work at a scale of 1 to 20 or 1 to 40 when they're doing design, but it's hard on a lot of urban sites to show all the necessary detail at 1 to 20. So what we do is I will ship them a drawing at a horizontal scale of 1 to 20, but we will provide a digital PDF of the same topo at a horizontal scale of 1 to 5, where you can see every shot we took, right? Because I think it's important that the civil engineer or the architect have a design that shows every shot we took, highs and lows, all that, all that stuff, conforms. They need to have something that shows that. And a lot of times you can't fit it all in a CAD drawing at 1 to 20, right? So we do that. We provide a separate signed PDF. I mean, sometimes we'll break it out. We'll have one sheet with the topo, and then we'll have another sheet with all the utility information. Okay, and that's a wet sealed PDF, right? And that's, the engineer can't come back to me and say, hey, I didn't grade to that low spot right there because you didn't have it in your CAD drawing. Well, yeah, because you were working at a CAD drawing at its horizontal scale of 1 to 20 with, half of the information shown, and you didn't check the actual deliverable that was shown at an appropriate scale. Like, look, if my engineer wants to work at a horizontal scale of 1 to 20, I'll give him a 1 to 20 scale CAD drawing, right? But he needs to look at my actual signed deliverable, right, that's drawn at an appropriate scale to show all the information he needs to do good design, right? So I will provide digital deliverables, and I will provide CAD files, but I have a signed, sealed PDF deliverable that is controlling. Now, can you edit PDFs? Yes, you can edit PDFs, but it's generally, it's a lot easier to edit a CAD drawing than it is a PDF, and I think there's some advantages to PDF. I have not yet heard of a situation where a surveyor has gotten in big trouble because a client doctored a PDF. I'm not going to say it's never happened, but I haven't heard of it, and it's a risk I'm willing to take, right? So as long as I have a transmittal, record of a transmittal with a signed, sealed PDF, I'm pretty comfortable providing digital files to the client. Now, I will say one other thing about digital files. So here's what happens to me a lot. I'll provide a design professional with a contract to do topo boundary. And in my contract, I typically include an optional task to do control for construction. So I'll say, the control I need to do a topo is not what you're going to need to build this site after it's designed. I'm happy to provide survey control for construction, signed sealed sheet and the design plans, monitoring of control during construction. I'll support your contractor if he wants to use machine control for his rough grade, whatever, but you're going to pay me for that, right? I'm going to charge you for that. Okay, and I don't know if I've ever had a client accept that optional task. They almost always turn it down. They don't want to pay for it. Okay, now here's what happens. We do the topo boundary, gets designed, goes to construction. The very first thing that happens is I get a phone call. Somebody wants my control. Okay, they want a CSV file of my control for the site. So here's what I do. I tell them, you can have my control, but you are going to execute client. You're going to execute this optional task that I put in my original scope, and you are going to pay me to go out and check the control before they start work, because I don't know what's happened to it since I was there. And you're going to pay me once a month or once every 2 weeks or once a week, depending on the project, to go out, monitor the control, make sure it's being used properly, that it hasn't been disturbed. And if I'm going to provide digital files for somebody to dump it into machine control, that's extra liability for me, and I need to get paid to monitor that work and make sure that it's done properly. That's the bottom line. And I have a separate agreement that I make the client or contractor sign that spells all that out, right? And I have clients sign it. Okay, so I do think you need to be careful about digital deliverables. You should get compensated from some of your extra. If you're going to provide digital deliverables to a client so that they can use machine control and save a bunch of money on their staking, or hire a contractor with an unlicensed surveyor that's got a total station, like, you should be compensated for your extra liability. And by the way, another quick thing about digital deliverables, and I put this in my contract, I do not provide digital deliverables if you are not a licensed professional. So you have to be a licensed surveyor, a licensed civil, or a licensed architect, or you don't get digital files from me, right? And in my release for the digital files, I have a clause, a term that says, if you're going to use this information to perform construction layout, you have to have a licensed surveyor in responsible charge, and that licensed surveyor has to sign the release. And he has to say, in my release, he says, I am going to be in responsible charge of the construction layout services. And that's how I make sure that I don't get in trouble for aiding and abetting unlicensed practice when I hand out survey control or a DTM, right? If you want that release, I'm happy to send you a copy because I wish every surveyor did that, right? I have surveyors call me all the time. They're like, hey, my client wants my CAD file. What do you think, Landon? I'm like, yeah, absolutely. Like, what do they want it for? Oh, well, the contractor wants to do some layout. Does the contractor have a licensed surveyor? No. Why are you giving them your CAD file? Right? That's crazy. I had a buddy call. He had a client that didn't want to pay him to set property corners, but then asked him for a CAD file so that the contractor could scrape the site. Like, no, don't give them the CAD file. They should have paid you to set the monuments. If there are physical monuments in place, the contractor can pull a string line, right? So anyway, don't be a bad business person, right? You know, yeah, you can give out digital deliverables. Now I know there's some companies that don't give out digital deliverables, right? I don't think that's the right answer either. I understand why companies do it, and I respect their right to make that decision. But you know, it's 2021. I need to provide digital deliverables to my client, but it's got to go to the right person. It's got to go to a licensed professional. I got to be protected from that additional liability, and I'm not going to aid and abet unlicensed practice, period. All right, so that needs to be in your contract. All right, enough about digital deliverables. Okay, the other very important thing you can do in a contract is you can limit your liability. And you want to do that as a land surveyor reasonably. You want to make some reasonable limits on your liability. Okay, so there's a couple things we have to understand though about limits of liability when we talk about contracts. Okay, one is I want to help you guys understand the legal concept. It's called privity of contract. Privity. Give credit to Dave Woolley. I think he's the first person to talk to me about this. Okay, privy of contract basically means you have some obligations to the person that you were in your contract with. That's called privy of contract. Okay, so if I signed a contract with Bob, I have privy of contract with Bob. I don't have privity of contract with Bob's sister, Jill. She didn't sign the contract. She wasn't a party to the contract. She does not have privity of contract. Okay, so as a general rule, you only have liability to those you signed the contract with. You have privity of contract. Okay, that's the general rule. Okay, but now this is really important. Surveyors are an exception. Okay, so it's still important to have a signed contract because you can still argue some privity of contract. Okay, but courts have found that because surveyors are licensed professionals, other people have the right to rely on their work, third parties. So you can be sued by somebody you do not have a contract with, and you can be liable to them for damages because surveyors have to meet the standard of care. That standard of care obligation we have is an obligation that comes from statute and common law and cannot be contracted with. So you cannot in your contract try and limit your liability as it relates to standard of care. You can't say both parties agree in this contract that Landon doesn't have to meet the standard of care for this work. You can't do that. It doesn't matter. As a licensed surveyor, you're responsible for the standard of care. It doesn't matter what your freaking contract says, right? And that applies to all kinds of professionals. It applies to real estate brokers. It applies to architects, it applies to civil engineers, right? Okay, so you cannot contract away the standard of care. Okay, but there are a couple things you can do, and I encourage you to do. One is you can try and place some reasonable limits on your liability. So I generally limit my liability to the value of the contract or some dollar amount. I can't remember if it's $50,000 or $100,000. I'm not going to tell you that's always enforceable by a court, but it's a good thing to put in your contract. And here's what you hope. You hope that things get to court, that you get a reasonable judge, and you look. So I'll give you an example. This came up. We had a project, I can't give you details, but we had a project come up. I got hired to do a one-day dirt topo on something, and I was provided control, right? 5 years later, I get a call, something got built. There were 3 other surveyors involved in the project after me, a bunch of other work was done. And like somebody calls up and is like, we're going to sue you for this $10 million structure, right? And I was like, nice try. I was like, you're not going to hang the $10 million structure on the guy that got paid $2,500 to do a one-day dirt topo with control that you provided, right? So make a long story short, yeah. I didn't have to pay that claim, right? Because there's not a reasonable relationship there between the value of the work that was provided and the damages, right? There's just not a logical connection there. It doesn't mean that people won't try and make it, but so what I'm saying is, you know, if you're only doing $2,500 worth of work, it could be tough for your client to try and convince a judge that you're responsible for a $2 billion disaster, right? That's not reasonable. Okay, I'm not saying they won't try and do it. So that's a good reason why you can to put a limit of liability in your contract, because a reasonable judge might say, hey, you know what, Landon only did $2,000 worth of work. He's not going to be responsible for your $2 billion disaster. You know, he's got a limit on his liability in his contract. But the flip side is also true. You know, if you put you say my liability on this contract is limited to $50,000, but you're doing $10 million of design work on a $50 million project, then a judge probably isn't going to limit your liability to $50,000, right? There's going to be some reasonable connection or nexus between the work you're providing and the compensation you're receiving and the amount of liability that you have. So I do encourage you to put a limit of liability in your contract with a dollar amount, but it's got to be reasonable, folks, right? You can't limit your liability in your contract to $1. A judge is going to look at that and be like, nice try, land surveyor. You're not going to do that, right? Okay, so it is good to limit your liability. Understand you cannot contract away the standard of care, and you cannot, you may be liable to third parties that don't have privity of contract. Okay, now, given that you are liable as a land surveyor to parties that you may not have a contractual relationship with because of the standard of care, what can you do? What can you put in your contract to help reduce that risk? I don't think you can eliminate it, but I do think there are some things you can do to manage that risk. So what I always put in my contract, and this generally goes in the scope of services, is we say, here's our understanding of what you're trying to do. Here's the purpose for which the deliverables we are providing you are intended to be used, right? So if I give you an aerial topo because you're doing some conceptual design, and you take that and build a $250 million skyscraper on it, you are misusing my product, right? So it's always super critical in your scope that goes with your contract to say, here's my understanding of your project. Here's the purpose that I understand you are going to use my product for. And I actually have some language in my actual contract that says, hey, if you hand out my survey to other people and they use it for a purpose for which it's not intended, you're going to defend me. So you're going to defend me, and I get sued for their misuse of my product that you gave them. You're going to bear my legal costs, right? I have that language in my contract, right? It might even be part of the standard CLSA contract. I can't remember, but that's really important. So you can limit your liability to third parties by putting some language in your contract or your scope that clearly says what your understanding is of the project, how you and your client agree that the survey is going to be used, and that if they distribute that survey to other parties with which you don't have a contractual relationship, and they use that survey for another purpose, you're not going to be liable. Okay, so those are some things you can do in your limit of liability. All right. Okay, so this brings me to this topic about what can you insure. So there is a very important relationship between your professional liability insurance, which I know all of you have, and your contract. Okay, so I want to talk about a few of those things because it's important. First of all, you need to understand that in most professional liability insurance policies, if you don't have a contract, you're not covered. Don't do work without a contract, right? That's a big deal. You don't want to be not covered. You want to be covered. So if you're doing work without a contract, there's a good chance your professional liability insurance carrier can deny you coverage. Okay, so that's important. Second thing is, even if you have a contract but you have no scope of services, there is also a chance that your professional liability insurance carrier can deny you coverage. So you need a contract and you need scope, right? That's important. Your professional liability insurance carrier wants you to have a contract and a scope. So do that, right? Or they can deny you coverage. And if you're not sure, go read your policy. I'm almost positive you will find that language in there, right? Those are exceptions to coverage. It's like, hey, knucklehead, if you go do work without a contract and a scope, we're not going to cover you, right? That's probably in your insurance policy. Okay. There are also, you could have a scope and sign a contract. And if you have poison, duty to defend language or other crazy language in your contract, you may not be covered. So your insurance company almost certainly in their policy told you, if you sign contract with poison, duty to defend language, we're not going to cover you. Those costs aren't covered. So that's another really important reason to not sign contracts with bad duty to defend language, right? Okay, now, let me wrap up. This is a really important business principle when it comes to contracts. Okay, and let me tell you why. Signing a bad contract. Clients will ask you to sign bad contracts. So will subs. Subconsultants will ask you to sign them too. Here's why it's foolish for clients to ask you as a land surveyor to sign a bad contract. Most surveyors are not worth very much money. Okay, I'll use myself as an example, right? I have a little 3-bedroom house on the south side of Stockton. I got a dog with a bad leg, and I got a crazy Hispanic wife, right? Like, I am not worth very much money. Like, Landon Blake's total net worth is not a very big number. Okay, so here's why it's kind of silly for clients to ask you to sign a contract that you can't insure, right? The only money you're going to get out of Landon Blake if there's a disaster is the money that's in my professional liability insurance policy. So if you as a client make me sign a contract that is not insurable to get your work, you just screwed us both, okay? Because, like, all right, you might take my house that's worth $200,000, but, like, you're not getting the $2 million in my insurance policy because now I signed a contract that's not covered, right? So what the business principle that I want you guys to understand, you have to tell your client this. Like, client, it does you no good to make me sign a contract that isn't insurable. The only thing a surveyor has that's worth any money usually is a professional liability insurance policy, right? And if you're a smart surveyor, right, like, your company building is not owned by you, right? That's in a separate corporate entity. Like, smart surveyors move all of their valuable assets to separate corporate structures so that they don't lose them in a lawsuit, right? So the only thing that you have as a licensed surveyor, if you're doing things right, that's worth any money is your professional liability insurance policy, right? That's why when you look at the table A for the land title survey spec, it has, like, whatever, item 21 or 20 or 22, I can't remember. It's like, I have a professional liability insurance policy that's worth X, and you put that on there if they ask you to, right? Because banks know surveyors aren't worth any money, right? So you got to explain this to your client. You have to tell your client, I can't sign this contract. It's not insurable, and you shouldn't want me to sign that contract either, because if I'm not insurable and there's a mistake, you're not going to get any money, right? So very tight relationship between professional liability insurance coverage and if you have a contract and what's in your contract. You need to understand that. Most professional liability insurance carriers will review a client's contract for you at no charge and tell you, yes, this is insurable. No, it's not insurable. Yes, it's insurable, but we think it's a bad idea for you to sign it, and here's why. Okay, so take advantage of them. If they have that service, you should definitely take advantage of it. All right, I don't see any questions yet. You guys are welcome to ask me questions if you want. I don't see any, but we're almost done. Okay, all right. See what I got left. Oh, 3 principles for contracts. Okay, this is the last slide, right? So I got 3 principles that you can use for all matters related to contracts, right? This is contracts for your work. It's contracts to rent equipment. It's contracts to lease an office. Any kind of contract, you can use these 3 principles. Okay, they're super simple, right? So here they are. Principle number 1: plain language. If you don't know what it means, don't sign it, right? Contract should not read like a Shakespeare play. It should be in plain English. Do not let lawyers muddle a contract to the point where it is not understandable. Okay, it's not necessary. We don't need to do it. If you don't understand it, either ask for the language to be simplified and clarified, or don't sign it. Okay, that's principle number 1. You should be able to read and understand your contract without a lawyer. Number 2, be flexible and reasonable, right? You should be willing to make small changes to your contract. That's part of the process. And let me explain why that's important from a legal perspective. If you get to court in a dispute, one of the things that a judge will look at in a contract dispute is whether or not the parties had roughly equal negotiating power in the negotiation of a contract. So here's why you do not want to tell a potential client or subconsultant in an email, my contract is take it or leave it. Because what you just demonstrated to a judge is that the other party of the contract did not have a reasonable opportunity to negotiate terms. And that is bad for you, right? So you want to entertain reasonable changes to your contract, right? And this blows my mind. I can't even tell you how many times in my career I've had a big engineering company send me a contract with some crazy poison pill language in it, and I asked if we can make modifications to the contract, and the answer is we just don't do that here. We just don't make changes to our contract. Okay, well, that is a really dumb thing to put in writing, okay? Because you've just demonstrated to a judge that the other party to the contract did not have a reasonable opportunity to negotiate terms, and judges don't like that, right? So the same principle applies to you. You need to be willing to reasonably negotiate reasonable changes to your contract language. Okay? I'm not saying you have to do whatever the other party wants, but you should at least entertain changes they may request and have a conversation with them about it, right? And you want to do that in writing, right? Do that by email so that you can demonstrate to a judge at a later date if there's a dispute that that other party had a reasonable opportunity to negotiate contract terms and did so and agreed to the final result, right? Okay, so that's the second principle. Be flexible, be reasonable, okay? Here's the other thing on that note too. You need to be, part of being reasonable and flexible is a willingness to be what I call reciprocal. So you should not ask for things in your contract of your client that you are not willing to do yourself. And I have this conversation all the time, especially with big engineering companies. So a lot of times big engineering companies will want me to indemnify them, that duty to defend language, for my negligence, but they are unwilling to duty to defend me for their negligence. In other words, if we both get sued because there's a problem on the project and it turns out that it's their fault, they should pay my legal costs, right? And the damages, okay? And a lot of times I'll have a big engineering company tell me, you have to defend us, but we're not going to defend you if the roles are reversed. I don't sign those contracts. That's not fair and reasonable. It should be reciprocal, right? And vice versa. You should not ask your subs to sign duty to defend language that you're not willing to reciprocate, right? You shouldn't do that. Okay? A reasonable judge is not going to like that. They're going to look at that contract and say, why is Landon defending you, but you weren't willing to defend him if the roles were reversed, right? You do not want a judge in a contract dispute to decide that you were being unfair and unreasonable. It is not going to go well for you, right? So don't do that, right? Contracts should be reciprocal, period. They should be fair. Now, that's one of the reasons why I like the CLSA standard contract and the ACE standard contract. They're very reasonable. When somebody sends me their own home-cooked contract, I get nervous because that usually means that contract is way too one-sided. And you shouldn't sign one-sided contracts. CLSA and ACEC have done a good job of developing fair contracts that treat both parties, the consultant and the client, in a reasonable way, and that's what you want in a contract, and that's what judges want when they look at contracts, okay? So the second principle, be flexible and reasonable. Okay, the last principle is don't bury nasty surprises in your contract. Don't do that to your client, right? Don't get to the end of the job and then there's some kind of small problem where you send your client some crazy bill and they're like, I didn't see that, and then you point to the fine print in your contract. Don't do that. That's a bad way to do business, right? That brings us back to this slide, right? What's the whole point of a contract? It's this box right here, mutual understanding, right? If you bury nasty surprises in your contract language, you're defeating the whole purpose of a contract to begin with, right? Which is not to destroy your legal opponents in court. It's to have a good mutual understanding between the client and the consultant. That's the whole point of a written contract. That, my friends, is good business, right? So those are the three principles, right? Use plain language. If you can't understand it, don't sign it. Be flexible and reasonable, right? It's not a take it or leave it situation. And don't put nasty surprises in the fine print, right? It's not a good business practice. All right, there you go. How'd I do? I think I'm doing okay. I got 7 minutes left. I went a little long. So I don't see any questions in the chat. I don't know, Kim, if you're there, if I'm just missing questions or if people are just all completely asleep because of this topic. Anybody there?
Oh, yeah.
Did we get any question, Kims? I don't see any.
Yes. Sorry, I couldn't find my unmute button. We've got two questions. The first one, what would a reasonable amount of liability be for a $2,500 project?
That's a good question. Okay, so I'll give you the two theories on that, all right? One theory is $2,500, right? So some people will argue, well, I shouldn't be liable for more money than I'm gonna make on the project. I hear that a lot. That's how a lot of contracts are written. Because surveyors have a standard of care, I don't think that's reasonable, right? So here's what I think is reasonable. Your client is going to rely on your work probably to build something. If you make a mistake and that something ends up in the wrong spot, how much is it going to cost to fix? That should probably be the limit of your liability. Now, I think if more surveyors understood that, we wouldn't have as many $2,500 boundary surveys, would we? Surveyors would demand to get paid more because they would actually understand the liability they're taking on. So yeah, I think what's fair, in my opinion, is you should be liable for the dollar amount of damages that could potentially be caused by your negligence, right? And that's why you should get paid more. So like, look, is a boundary survey for a skyscraper the same price as a boundary survey for an alfalfa field. Yeah, those probably shouldn't be the same price, right? Way more liability in the first example, right? So surveyors should price liability in their fee estimates, and a lot of us surveyors don't do that. So good question, excellent question. We got one more, Kim?
Got two more for you. Do you ever sign contracts with liquidated damages?
I am probably not prepared to answer that question. I'm a little bit worried about giving the wrong answer. So let me give you an example of what I think liquidated damages is. So for example, let's just say you agree to have your survey done by a certain date. And then if you miss your deadline, they can't open the new shopping mall in time. And so for every day you're late, they get to assess monetary damages for the money they lose because the mall's not open. And those are really dangerous. I suspect in most cases, liquidated damages are not an insurable risk under your professional liability insurance policy. I would probably not sign a contract with liquidated damages in it. And certainly if I was going to sign a contract with liquidated damages, I would want to make sure that that was a covered risk under my insurance policy. And again, the same principle applies, right? So like, let's just say you call your insurance carrier and they say, yeah, we don't cover liquidated damages, Landon, sorry. All right, well then you got to call your client and say, hey client, like I can sign this contract, but you're not going to get any money out of me if something goes bad. So why don't we change that language? Now, let me tell you something like, here's what lawyers are really good at. Lawyers are really bad at drafting contract language, but they're really good at finding creative solutions to that kind of problem. So here's a better solution in that problem. If the client really wants you on the hook for damages if the mall doesn't get opened on time, like maybe you need to go bond for that. Like maybe you need to get an extra insurance policy that will cover those damages. And like you can probably buy that on the open market somewhere, right? But there's a cost for it, right? So occasionally I will have a client that says, hey, Landon, we know you carry $2 million worth of liability insurance, professional liability insurance, but we would like you to carry $10 million on this project. Okay, and then I say, no problem. I call my professional liability insurance carrier and I say, hey, how much to get an extra $8 million of coverage on this one project? And they say, what's the project? How long it's going to be? What is it doing? They give me the quote. I turn around, I tell the client, here you go. For an extra $8,000, you can buy yourself an extra $8 million of professional liability insurance coverage. And some clients will pay for that, right? So if I got in a situation where the client really wanted to be covered for liquidated damages, I would be looking to either bond or acquire insurance to cover that risk. Excellent question.
How do you deal with, the question says, how do you deal with paid when paid clauses?
Yeah, good question. Okay, so let me explain that. So a lot of contracts have a paid when paid clause. Okay, what that usually means is you don't get paid till your client gets paid, and that's usually when you're working as a sub. So it's usually when a surveyor sees this, they're working with for a civil engineer or an architect. Okay, and so what the civil engineer is saying is, I'm not going to pay your bill till I get paid by my client. Okay, so I have 2 or 3 quick things to say about that. First of all, in California, it's illegal. So paid when paid language is not legally enforceable in California. Second of all, if you're going to sign a contract like that, you better know your client's client because you're essentially extending them a line of credit, right? And the whole reason why your client wants you to sign that language is because they don't want to owe you the money if their client doesn't pay. So essentially, not only are you so when a surveyor normally works for another party, if they're not getting paid full up front, they're extending a line of credit. So if you're signing a contract with a paid when paid clause, not only are you extending that line of credit to your client, you're extending that line of credit to your client's client. So then my question for you would be, what do you know about your client's client? Are they creditworthy? Right now, there may be a business decision why you want to take that risk, but it is a huge risk, and the clause is not legally enforceable in California. So yeah, I don't like paid when paid. It is not good, but clients will ask you to do it. Good question. Excellent question.
I have one last question for you.
Okay.
Should a contract have an expiration date if not signed?
That's a really good thing. So that's a good question. Thank you for whoever asked that. So here's what I do. Generally, when I make a proposal available, when I send over our agreement and the scope of services, I generally say subject to revision if it's not accepted in 30 days. So I had an example. I gave a client a price for a lot line adjustment back in November when things were really slow. And now they called in July and they want it for the same price. And I said, like, nice try, now it's double, right? You waited until middle of summer and we're slammed, and yeah, it's not the same price that it was in November, right? So yes, I think that is a good idea to put some kind of language in your contract that says it's only valid for short period of time, and as a general rule for me, that's 30 days. Thank you for bringing that up. I forgot all about that. So Kim, thank you for those questions. Those were great questions.
Thanks, Landon.
All right, guys, appreciate it. Have a good day. Have a good weekend.
Bye, everybody.
All right, well, we'll see how